Assalamualaikum warahmatullahi wabarakatuh. My name is Nuraqilah binti Zaini and my matric is number 1170412. Okay, firstly, I would like to thank Prof. Dr. Azman Abdurrahman as my examiner for today. Okay, so the topic for my final project is the punishment of stealing for children according to Islamic law and Malaysian law. These cases of stealing are often broadcasted in mainstream media as well as in social media. This act of stealing is not only committed by adults but also children. No matter how serious the offense committed by the child offender, the punishment imposed on them is different from the punishment for the adult offender. There are certain provisions for these child offenders according to the Islamic law as well as Malaysian law. Move to the methodology. To collect data and obtain accurate information, this article uses reference methods from articles, books, journals, and more other materials. This article also uses the interview method by interviewing the relevant respondent to strengthen the findings of the study. In this research, the three main research objectives are firstly to know the minimum age of criminal responsibility under the Malaysian Sharia law, secondly to identify the minimum age of criminal responsibility under Malaysian law, and to know about the opinion of the interviews regarding stealing cases by children in Kelantan. Okay, now we move to the discussion. Firstly, the minimum age of criminal responsibility under the Malaysian Sharia law. Firstly, there are 11 states in Malaysia defines young offenders as a person over the age of 10 years and less than 16 in the Sharia Criminal Procedure Enactment, which is Federal Territories, Selangor, Negeri Sembilan, Johor, Malacca, Pahang, Penang, Perak, Terengganu, Kelantan, Sabah, and Sarawak. Meanwhile, Perlis is the only state that provides the term remaja or youthful in Sharia Criminal Procedure Enactment. It is defined as a male or female person under the age of 18 years. In addition, Kedah does not define young offenders because there is no relevant provision on puberty or mukallaf in Sharia criminal law. Okay, so now we move to the minimum age of criminal responsibility under Malaysian law. Criminal responsibility under Malaysian law divided into two categories. Firstly, children under the age of 10 years, as provided in Section 82. These children are considered incapable of committing a crime, which means they cannot be charged with any criminal offence. And secondly, children aged 10 years and above and under 12 years as provided in Section 83 of Penal Code. Children under this category are considered incapable of committing a crime unless there is evidence that these children know and are aware the act they committed was an offence. And then, Section 2 of the Criminal Procedure Code Act 593 defines that young offenders is a person who has been convicted of an offence punishable by a fine or imprisonment for those at the age of 18 years or more and under the age of 21 years. Okay, so now we move to the interviews related to stealing cases by children in Kelantan. From the interviews I did with some of the respondents, I found that children less than 12 years of age shall not be convicted of any criminal offence which shall be deemed to be insane under Sections 82 and 83 of the Penal Code. Furthermore, the punishment to be imposed on children found guilty of stealing will be sent to rehabilitation centres or special schools or given custody to the right person if such children are found neglected in terms of their care or right as children. The conclusion for this study, regardless of whether the child is involved in stealing or any crime, the provisions of the punishment remain the same which based on the court decision. The differences between these two laws are the minimum age of criminal responsibility against these children. These differences in usage and definition of the age of children and young offenders cause confusion in the legal system in Malaysia involving two different jurisdictions. That's all from me. Thank you.